Well, hello there, attendees. My name is Christy, and I am so excited that each of you have chosen to join us, especially on a Friday afternoon. Trust me, we don't take it lightly that you've taken a little bit of time out of your day to join us. So today's conversation is centered around the CCPA and CPRA compliance in the trucking industry. Leading us today will be Tenstreet's General Counsel. Her name is Shannon Wheeler, and we are looking forward to a really, really great conversation with her today. So I'm just going to open us up with just a couple of reminders or announcements, some housekeeping rules. And then we'll go ahead and turn it over to her. So the first thing is we want to make sure that you leave this webinar with a really good understanding of the CCPA and CPRA compliance as we understand it today. So we want you to use the questions box in the GoToWebinar control panel to ask questions. We have designated some time at the end of today's webinar to get all of those questions answered. So make sure you have your control panel up, and then you just type your question in the questions box. You're going to receive a recording of this webinar about 24 hours after we end today. So tomorrow you'll be able to see it. It comes directly to your email inbox, and you can share it with folks from your own respective teams. The last thing is when you are looking in your GoToWebinar control panel, you're able to click there's a little icon at the top to take a screenshot. So if we're sharing something that is of specific interest to you and your business, you can go ahead and just take a screenshot. It'll download it right to your desktop so that you can refer back to it later. And I can't reiterate it enough that we do really want to answer your questions, and we will have some time designated at the end of today's webinar for it. So before I turn it over to Shannon, I just want to thank you all again for joining us, and we are going to just go ahead and jump right on in. Hey Shannon, go ahead and let's get started.
Awesome. Hey, Christy, thank you so much. I'm so happy that you are here with me today and helping me out. And thank you all for joining on a Friday afternoon in the middle of July. I'm sure all of you, if you're not doing something better than this, you at least want to be doing something better than this. But I'm really happy that you're here with us to talk about this interesting and very timely topic about the CCPA and the CPRA. And so specifically what we're talking about here, and we'll get into all this later, is consumer rights and consumer privacy as it relates to California, because California has passed these big, broad, sweeping privacy laws. And so happy that you're here today talking with us about these things. Before we get started, though, I just wanted to mention, I don't know if we have anyone joining us here today that might be going to the ATA Legal Forum this coming next week in sunny San Diego. But if you are going and you are going to be there, please look me up. I will be there, and I would love to see you, shake your hand, say hi, and hang out while we are there. So I try to go to all of the sort of trucking legal conferences and meet those who are in the legal industry and stay up to speed on all of the new topics and talk with you about the things that are important to you. So if you are going to be there, I would love to see you and meet you. Okay, so let's dive in. Next slide. So as always, I have to give this legal disclaimer. The information in this webinar is for educational purposes only. It is not legal advice. We always recommend that you consult with your own legal counsel on all of the issues we talk about, and specifically with regard to the CPRA and your legal obligations as it relates to that. I highly recommend you get a privacy specific lawyer, and I have a few that I am happy to recommend. So as we go through these today, if you have questions, definitely send those in and we will do our best to answer them. But really specialized privacy lawyers are the best people here to dig into the really nitty gritty on these subjects. All right, so today's agenda. I'm going to do just a general overview of the CCPA and the CPRA and what those stand for and what we're talking about here and how they differentiate. I'm going to talk about who it applies to, and then I'm going to talk about how to comply, the three major ways to comply: individual rights, contractual requirements, and disclosure obligations, and we'll talk about how that relates to your Tenstreet services as well. And then we're going to talk about data security standards and data protection, because that is a piece of the CPRA. And then we're going to talk about how you can have an action plan for getting CCPA compliant if it applies to you, and then we'll take questions. So, and if you have questions along the way and there's time and, you know, Christy can jump in, no worries. I don't think this is going to take a full hour, but it might if we have a lot of questions, and I love the discussion back and forth. So, okay, so just to give a broad overview of the CPRA, what we're talking about here is the California Consumer Privacy Act. It was actually passed and effective January 1 of 2020, but that January 1 of 2020 law that went into effect in California actually carved out HR data and mostly was not applicable to employers. And so if you heard about the CCPA, you might have been like, yeah, I've heard about this, but it's not something we have to do anything with yet. That was totally fair. And so you don't need to worry. Oh, it's not like you haven't been in compliance for 3 years. It just didn't apply to you or most employers in 2020. However, there was actually, it was by the voters in California voted that they wanted these rights to apply to them as it relates to employment. And so the voters decided, and the California Privacy Rights Act, that's the CPRA, was enacted, and it amends the CCPA. So really going forward, if you just refer to CPRA, you're talking about the newest law that's in effect, or you can still say CCPA, but you have to understand that the CCPA really is the terms as amended by the CPRA. So all that boring legal jargon, what does this mean? It actually was effective January 1st of this year, but they specifically set a date that for enforcement. They said it's not going to be enforced January 1st of 2023, and it actually won't be. They said it can't be enforced until July 1st of 2023. And you guys are probably like, wait, it's July 14th. Do not dismay. California State Court actually said, nope, it cannot be enforced yet, and they have delayed enforcement of the CPRA until March 29th of 2024. So now I highly recommend you don't wait until then if it applies to you, but all basically that we're saying is that the CPRA cannot be enforced, as we'll talk about later, until March 29th of 2024 as it relates to the regulations. So the California agency in charge of enforcing the CPRA issued regulations, and this court said you have to wait 1 year from the issuance of the regulations until you can go start enforcing it. So that's what we're talking about. And since those were issued on March 29th of 2023, they're saying that the agency cannot enforce them until March 29th of 2024. So we still have a little bit of time on a lot of these matters. Okay, so a little bit more overview. Thank you, Christy. The CPRA changed many provisions of the CCPA to now apply to employers. So specifically when we say employers, it applies to protect the data of employees, owners, directors, and independent contractors. So, so what does that mean? It gives employees and prospective employees, so those that apply to your organization, certain rights. And then it also means that you have to have or give certain disclosures, basically notices about what you do with the data, and then you have certain rules regarding safeguarding that data and restrictions on who and how you can share the employees' data. And so the agency that I was talking about, the CPRA also did create the California Privacy Protection Agency that essentially is charged with enforcing the CPRA. And so it's an independent agency. It's going to implement the law, implement regulations for the law, and then they are the only thing that can enforce the CPRA. This agency is, and we'll talk about it here in just a little bit, is the only enforcement agency, and they do that with fines and penalties. And we'll talk about the specifics of that here in a little bit too. So that's sort of a big, broad overview of the CPRA and how we got here and how it applies to California. So let's talk about that applicability. Thank you, Christy. So what does it apply to? How do you know does this apply to me? Does this apply to my company? It applies if you hold the data, if you hold the HR data of individuals in California. So applicants, employees, independent contractors, if you have any of their data, like they've applied to you or you employ individuals in California, if you are a for-profit organization, meaning that you're not a charity, and then if you have more than 25 million in gross revenue, then this law applies to you. So they specifically put that 25 million in there because there are compliance costs that come with this, meaning you need to speak with attorneys, you need to implement procedures and policies and things along those lines. And they didn't want small organizations to have to struggle in dealing with this. And so they put that 25 million in gross revenue on that list. Now that 25 million in gross revenue is global gross revenue. So not California gross revenue, that is global. So if you have all three of those things, then the CPRA is applicable to you. So let's talk about how to comply. So these are the three main obligations, and then the rest of this webinar I will spend digging into what these main obligations are. So the first thing is that it created rights for individuals with regard to your data, with their data. And so we're going to talk about those, and you will have to, your obligations are you have to honor the rights that are granted to those individuals. The second thing that it did is it said if service providers or third parties will hold this data for your company, you have to have an agreement with them. And not only do you have to have an agreement with them, the agreement has to have specific provisions in it, mandates that the contracts have specific provisions in it. And so we'll talk through the details of those, and we will talk through how Tenstreet, as your service provider, has already met this requirement for you. And then the last main obligation is these disclosure obligations, which really relate to a privacy policy and what is called a notice at collection. So we'll talk about what those are, how you can implement those with your Tenstreet services, and some other details with regard to those. So let's dive into the first thing, which is the first obligation, which is what are the rights and how do you honor those rights? The first right is actually pretty easy, and that is the individuals, remember this is only for California residents have this right. So an individual who resides in Oklahoma does not have these same rights to their data as this individual in California. Now I say that because I want to point out, and I probably should have pointed out this earlier, California was this broad sweeping data privacy law. Of course, it starts in California. We expect to see these kinds of laws spread across the country, and there potentially even be a federal law that is equivalent. So the CCPA is sort of like GDPR. It's different in the requirements that it has, but it's essentially another privacy law, and we expect to see these pop up in states all across the country. So keep a lookout for that. And then there's also been proposed federal law, which surprisingly enough, California was very against having a federal law because they want their law to govern. And as soon as the feds put in place a privacy law, then that would govern all states. And California doesn't want that. They want their sweeping privacy regulations to control. So keep in mind when you are going through these individual rights that they only apply to those individuals that reside in California. Now, of course, you can give them, you can do this for everybody, all of these rights for everybody anywhere that they exist, but you're only required to do it for those in California. Okay, so the right to correct, what is that? It means that an individual has a right to correct inaccurate personal information. So you might be like, what does this mean? I don't even know what that means. Okay, well, personal information is basically any information that could relate to or identify an individual. It's everything from their name to their address to even sensitive personal information, which is sort of a separate carve out, which is social security number, date of birth. There's things like IP addresses, location. Personal information encompasses a great deal of information. And it is almost certainly everything that you would have about somebody who either applies to or works for your company, you would have their personal information, and almost all of that data would be considered personal information. So the next question that if you're thinking like I do, you might be thinking, okay, so I have their personal information. What does it mean to have to correct it? Does that mean I have to correct if they don't like their supervisor's evaluation of them, or if they don't like some, document that we filled out about them noting, what the information, how they were as an employee, or notes about how they, qualified as an applicant? No. There are what the law defines as subjectivity and materiality exceptions, meaning that the individual only has a right to correct objectively false information, such as correction of their address if they've moved, or correction of their phone number, or social security number, or the spelling of their name. So we're talking about very objective, factual information about them if they, if it changes or if it is incorrect. They do not have the right to correct subjective information. Now, I say all of this, but I want to kind of qualify it a little bit. One, because I'm a lawyer and that's just what we do, frankly. But two, also because these are untested. These are what we have seen written in the law and what we have seen written in the regulations. None of this has been enforced yet. There are not court cases telling us what this really means. There is not a history of enforcement of this law by that agency where we really know what this means. So we're sort of just grasping at what we think it means. And I am certain that this will eventually all come out in the wash. And will take several years to develop as we sort of figure out what does this right to correct really apply to and what it doesn't, and what does it not apply to. But what I cannot see is a court saying, and the regulations say this, sorry, can you go back to that last slide on the right to correct? I cannot see an individual being able to correct evaluation notes, things like that. There also was a note in the regulations that said that the right to correct does not mean, let's say an individual updates their address. It does not mean that you have to go through all of your prior records, including all old emails, all old, documentation of a subject, and correct that. It just means you have to correct the current information that you would have on the individual as far as like reaching out to them, noting it, and then correct it on a go forward basis. So there's a lot of sort of ambiguity around the right to correct, but those are the sort of nuts and bolts of how we think it's best to operate on a go forward basis. So let's go to the next right, the right to delete. Thank you, Christy. Okay, so this right to delete, I'm going to talk about what it is, and then I'm going to talk about how Tenstreet has done this and given you this ability to comply with this. All right, so this says that an individual from California has a right to have you delete all the information that you hold with them. We might be like, well, wait a second here. I don't want to delete all the information that I have on a particular individual, especially if they worked for me, or I might have legal obligations for why I have to maintain that information, or what do we have to delete? What can we keep? So the regulations have sort of vetted out that it's personal information, quote, collected from the individual. And so that what they mean by that is that it's not necessarily personal information that the organization creates about the individual, or information that is received from other sources. So that naturally it totally exempts from this right to deletion background checks, performance evaluations, complaints, investigative reports, communications discussing the individual. But also, they created an exception saying that a company may refuse to delete data that is necessary to comply with other applicable laws. So obviously there's tax laws, and there's employment laws, and there's specific to the FMCSA laws around how long you have to keep information and how long you are required to keep information. So you may keep or refuse to delete data for those reasons as well. And then sort of one of the very broad sweeping exceptions to this right to delete is that you can refuse to delete data if deletion would hinder potential legal claims and or legal defenses in the future. So that's one of them as a lawyer. And then as I'm sure what you all are thinking of is, I'm not going to delete all the information that this individual has about me. Let's say a driver resigns under very poor circumstances and then wants you to delete all information, but then wants to go sue you for discrimination, and then you wouldn't have the information to defend yourself. The law says you get to keep that data for potential future legal claims. So that's a big broad exception that you can claim just about all data under, at least past a certain, up until a certain time frame. There are other exceptions as well. I did not want to go into all of those specific exceptions because there's like 12 of them, and the 3 that I just talked about really kind of encompass all of the potential, reasons why you might, want to not delete something. But let's talk about when deletion may be appropriate and consistent with, like a data retention policy or things along those lines, and how you would be able to do that in Tenstreet. So you might consider if an individual comes to you requesting to delete, you might consider it appropriate if like they've only applied to you and never worked for you and it's been 5 years, or if they only ever submitted like a lead application through Tenstreet and then you just have their name, telephone number, and and email address, and they're from California. Those might be appropriate under those circumstances for, hey, this is the information that we can delete. They never worked for us. There's no reason for us to, believe that there's a legal claim here. There's no reason for us to believe that, there's no other applicable laws about it, things along those lines. So those are times when you might, sort of build in a data retention policy about when you would be willing to delete information that you might not otherwise have to keep. And one of the really good benefits about deleting data like that in particular, which you have other business purposes, you want to keep that lead form, and there's probably an exception that you can find to be able to like refuse that right to deletion. But you might want to also consider, hey, we might want to keep it for this business purpose, but also consider the business purpose of it's a risk to keep this data now, because this kind of data is becoming landmine data. If it gets hacked, or if it gets released, or if somebody else gets a hold of it, somebody out of your organization gets a hold of it, then is it sold and your liability for it. So just consider the fact that there might be good business reasons also to delete it. So that's the right to delete. Again, it's all still very new. We don't know what the agency is going to say about this more. We don't know what decisions and opinions are going to come out of this more. So, and let me talk about how you can do this in Tenstreet now. So I was so excited, and I'm sure you all are as well, but we created a new tool for you to go in and be able to delete a subject. Christy actually could probably demonstrate that for you and talk about where that is way better than I could. Christy, do you want to chime in and talk about, I'm sorry, I'm totally catching you off on the spot, but how somebody would go about deleting a subject?
Absolutely, Shannon. I'm happy to talk about it because, it's been a long time coming. And so I know a lot of people, like even at our user conference, there were cheers all over the room when we announced these features. So the first thing I want to let everyone know is there are 2 different features. They're related, but they're separate for the CCPA and CPRA compliance. And so the one that we'll talk about is not really the merge, it's the delete feature specifically. And so we have some controls around it. So if you're familiar with the user types in Tenstreet, just know that you have to be a primary user to have access to this feature. And once it's marked for deletion, it's a very simple process, but once you've marked a subject for deletion, Every primary on the account is going to get an email. It's going to have all of the information about what will be deleted and the date that it's going to be deleted. It doesn't happen in that instant. We do wait a few days just to give you an opportunity to, if you change your mind, then you're able to, unmark it for deletion, so that that subject will remain in your dashboard. Because you know what, once that date happens, it's deleted, it's gone. It is gone, because again, this is to help you maintain that CCPA, CPRA compliance. And so we do have some detailed instructions that are available. So if around August 1st, everyone will have access to this feature. But if it's something that you absolutely need access to, just reach out to your account management team at account.managers@tenstreet.com, and we'll be happy to show you how it's done.
Awesome. Christy, thank you so much. And so the reason why we send that email is there's a number of reasons, but it's really key for really two purposes. One, so that you have record, and so the CPRA allows you to keep records of complying with this right to delete. Well, that's that record for you. That's that email that says, yes, we are going to save this, that we deleted this individual's data on this date. And you can then keep that record under the CPRA forever, or inconsistent with your data retention policy. But it also does another thing, and that is that it allows you to sort of have a pause before the information is totally gone, so that everybody knows and agrees, yes, we want this information gone. And then once it's gone, like Christy said, it's gone. There's no getting it back. Tenstreet cannot recover it. That's why we give you, and you can even configure the number of days that you want after you get that email. So it's not immediate. It's not right as soon as you hit that delete button, but it is after you get that email, it'll tell you 24 hours, 48 hours, whatever that time frame is. And after that time frame, it is gone, and not even Tenstreet can recover it. So awesome. Thank you, Christy. Let's move on to the next right. The right to know. Okay, so this is essentially, this is the, hey, we need to do some busy work up front so that we, create a privacy policy and notice of collection that are linked to various places and given to employees in California, so that they know what information we have on them. So there's this, the right to know, and what you have to do is they have a right to disclosure. Well, what does that mean? Well, okay, we're still figuring this out, but it means the categories and the sources of information that you have on them, as well as the purpose for having that information. This is essentially the type of thing that would be listed on a privacy policy. Like, we collect all sensitive information consistent with the FMCSA regulations as required on the application. We collect, that's the kind of categories and sources of information that you would have. And they can be really pretty broad. So that's, if you get a request for a right to know their information, it can be as simple as responding with a link to your privacy policy. So then the other right to know is this right to specific pieces of personal information. And this is where privacy lawyers everywhere are scratching their heads, because no one really knows what they're talking about here. There's very little guidance in the regulations on this. And the regulations actually create more ambiguity, because they say the response to this right request should not include sensitive personal information. And so that's a sort of attempt to say, hey, if this were to get hacked or something along those lines, you wouldn't want to include this information, sort of a data privacy, data security measure. So the regulations say, don't, to these rights to request specific, right to know specific pieces of information, don't respond with social security numbers, don't respond with login credentials or health insurance numbers. So they kind of create ambiguity. It's like, okay, well then what do we respond with? And it also says, the regulations say that it doesn't mean you have to provide copies or of documents and records. If we think it is actually saying, you have to say, we have your name, we have your address, we have your, and like this is what it is. This is what we have your address as. This is what we have your phone number as. This is what we have, you know, your credit reports. This is, but it might not mean that. It's really ambiguous, and we're sort of waiting for additional guidance on this. But what I do want to point you to is, so that, remember, this only applies to California residents. There is also, and employers are being advised, and it's a best practice to, when you get this sort of request for a right to know, they are also keeping in mind this California personnel records rights, which is another law unrelated to the CCPA, which says that when an individual in California, a California employee, requests a copy of their personnel file and their personnel records, you have to provide them that. So essentially we have two laws at play here that could be interpreted to mean the same kind of information that you as an employer might want to provide. So sort of here you want to keep in mind though, so you do get a request for this right to know, you know, you might also be sort of responding to a California personnel records rights sort of request as well. And so you might want to just follow your procedures that you would for that kind of request, provide them with the copies of documents, provide them with the copies of records. Overall, the best practice here is have a policy on what you're going to respond to for these right to know requests. Talk with a privacy lawyer about how you do that, and have some procedures in place for how you want to respond to that. And then I'm sure in several years we will have sort of vetted this out and know better how to comply with this. But those are kind of the limitations of what we know right now. Okay, the other thing that the regulations made clear is that there is only a 12-month look back period. So if they request specific pieces of information or categories of information, you only have to tell them what you have for the last year. So you only have to go back 12 months. And then it also, and we don't really know what this means, but it excludes requests that are manifestly unfound or excessive. So like, what I would envision that means is you do not have to provide them with every single email that either involves them, that they were involved in, or that mentions their name, right? Because that would be very excessive. That's sort of supposition though. We don't know how far this goes, but it seems like it would be really excessive for them to request any and all emails that ever mention their name. Or that they were ever included on. But if they do request that and you find, oh, well, it's really only 5 emails, well, then maybe it's not excessive to produce that information. So there's just sort of this give and take, and we're sort of trying to figure out what these rights to know mean. Lastly, though, one thing that it does exclude is privileged materials. So if you are talking to a lawyer about a specific request that you have on an individual, or you have talked with a lawyer or some other privileged communication about that individual, they do not have a right to that information. So that is what we know about the right to know. Next slide, please. Let's talk just briefly on the sort of procedural requirements around these rights. So if an individual makes a request to exercise these rights, you have to verify their identity. And it's a best practice to verify the identity with at least 3 pieces of information. So you have to make sure that you're verifying that you are providing this data to the individual, and there's sort of some industry standard practices for verification of identity, so make sure you're doing that. You have to respond to these requests within 45 days. So the regulations sort of clarified that. And then these rights that they're requesting also include all the data that you have held with service providers. So if you get an individual that requests their right to delete, like we were talking about earlier, that applies to deleting that data with the service providers as well. So keep that in mind. Okay, so one of the things that came out with the CPRA and this regulations is that, remember, the agency is the only one who has the right to enforce these laws. The good news is that there is no private right of action under the CPRA, meaning that individuals cannot sue you under the CPRA. That is great for something out of California, because as we know, in California, there's a very litigious area of the country. And so that's the good news. The bad news is that the agency has a right to fine your organization up to $2,500 per violation. And then if they find that the violation was egregious or essentially intentional, then up to $7,500 per violation. So it could add up. Now, there's been sort of some speculation about how aggressive is the agency going to be, how aggressive are they not going to be. The thought is they're going to be fairly aggressive. They're going to start with supposition, right? So don't take this as final anything that I'm saying, but the supposition is really that they're going to start going after the big guys first, and really looking at and enforcing things and making examples out of very big, large organizations that operate in California. And so we'll see how it goes. But I wouldn't not comply if you're, let's say, a smaller organization. I would still take this seriously. I would still take steps to comply and still try to do your best to apply, comply with this law. But just keep in mind a year from now, or really, a year from March 24, we're going to have a lot better idea of how these laws are applicable, and how the agency is enforcing it and things along those lines. Okay, so let's move on and talk about the contractual requirements that the CPRA says that you have to have with service providers and with third parties. So if you are going to have a service provider or a third party that will have the personal information of these, we call them data subjects, of individuals in California, and so that would be Tenstreet. Tenstreet would be considered one of your service providers that has personal information if you have these individuals from California. And it would also be any other service providers that you have. You might use a payroll provider, you might use, other third-party independent contractors, things along those lines. These contractual requirements are gonna apply. So it'd be good to sort of think through all of your practices and all the third parties that might have personal information of California individuals. And then once you kind of gather out who those service providers and third parties are, then go make sure that you have what is called a data processing agreement. It doesn't have to be called a data processing agreement. It can be called something else. Or these terms can just be in your regular everyday contract with them. But this California law requires very specific terms with all providers, service providers and third parties that might have your HR individuals' data, personal information on them. So what are these terms? I'm not going to go through all the terms because they are fairly long, but it says that your service provider cannot sell or share personal information. Okay. Tenstreet does this. I'm going to kind of jump down to the third point, and then I'll come back to the rest of the things in the second point. And that is that Tenstreet has a data processing agreement. We put this into place and implemented it. I think it was before the beginning of this year. It is out there and it applies to each and every one of our clients. You can see the link to it linked right there on the slide, and then you can just Google Tenstreet data processing addendum and you will pull it up. And so we have these terms already in place for all of our customers. And that includes that it says that we do not sell personal information. So we say in numerous places that we do not sell your data, and here is one of them, because we do not sell data. So I just wanted to point that out really quickly. So, but all of your service providers, the contract terms have to say that. And when they say share personal information, that doesn't mean that you can't share it with other service providers for other purposes, business purposes. So for example, you might instruct Tenstreet to share your data with ad agencies. And of course, might not be all data, but certain data with ad agencies, or to share certain contact information or certain information with third-party recruiters. You can share it with other service providers if these terms and agreements are in place. And so what it means by share information is essentially like selling it. That's kind of what we're talking about with that first bullet point. Other provisions are that you cannot retain, use, or disclose that personal information for any purpose other than performing the services specified in the business contract, or is otherwise permitted by the CCPA. And so, okay, we're only going to use that data to perform the services that we perform for you. It says that the service provider must comply with the applicable CPRA obligations. Yep, we do that for you, and we've got that one covered. And then that the employer will have the ability through these contract terms to take reasonable and appropriate steps to ensure that the service provider is complying with the CPRA obligations. Okay, so those are sort of the big main terms that it requires. There's a whole bunch of nitty-gritty and very meaty terms that are also required, and you can read through all of those and through all of Tenstreet's commitments to you in that data processing addendum. So wanted to point that out. You're covered with Tenstreet. Make sure that you sort of figure out what other third parties have this data and go get those contracts in place with them as well. All right, so let's move on to sort of the disclosure requirements. Okay, there's the CPRA. There's two main disclosure requirements, and that's the notice of collection and then the privacy policy, and we'll get to the privacy policy next. So you might be like, what is a notice of collection? Well, it's a notice that must be provided to the individual at or before the data collection occurs. Okay, and then it has certain requirements that the notice must state. It has to state every category of personal information that you collect, the purposes for which you will collect it, how long you will retain it for. And when you say how long you will retain it for, you can use very broad terms with this. You don't have to say we will retain it for 5 years. You can say we will retain it as long as required by law, and as long as it is no longer being utilized for business purposes consistent with, reasonable standards. Like, you can use very, very broad language here. Again, you're going to want to consult with a privacy lawyer on the drafting of this notice of collection. You will want to say, and most of you do not sell your data. So thinking about companies, there are companies out there that do sell their data. And if you sell data, you have to disclose that you sell data, and then you have to provide the individual the ability to opt out of selling data. I've not gone into the details of that very much here because most of our clients, if not every single one of you, would never be in the business of selling data. So if you do not sell data, you have to state on the notice of collection that it will not be sold. And you want to put that in big, sort of bold letters so that they can see that. And then in the notice of collection, you have to provide a link to your privacy policy. Now, sort of funny thing, you can have your notice of collection can be in your privacy policy, but you have to also link the privacy policy to the notice of collection, even if the notice of collection is included within your privacy policy. So there's sort of this big loop because, we're talking about some California laws here. But so those are the big broad things. There are notices of collection that you can see as they go by, and then you want to look at what data you actually do collect. Of course, you collect all the information that's on the Intella app about individuals. You probably collect other categories of personal information if you're going to hire an individual, things along those lines. So you'll want to look at all those things that you collect when you're creating this notice of collection. Okay, so how can you link it? How can you provide that to individuals at or before the point where data collection occurs? Well, you can do that through a link. So it can be a link on your website. It can be a link on your Intella app. And so sort of talking through that as it relates to your Tenstreet services, one of your first sort of opening pages, if you have this notice at collection, please send that over to your AM, and we can create on the first sort of opening page of your Intella app before they ever start inputting any data. We can put a statement for California residents. Please see this California Privacy Rights Act notice at collection, and we can link it there so that way that the individual can click on that link. And that's the easiest way that I recommend doing it. The other easy way is, since this notice at collection can be included in your privacy policy, I would recommend that you update your privacy policy with a notice at collection, and then send your AM a link to your privacy policy, and we link that privacy policy at the bottom of every single page of your Intel app. So those are the ways that you can, sort of meet this notice at collection requirement. So think through all of the ways that you collect information from individuals, applicants, employees, things along those lines, and then put a link to your privacy policy or a link to a notice at collection at or before the point where you collect those. All right, moving on to the privacy policy. So for the CPRA, it says if you are going to have or collect HR data from individuals out of California, and if this law applies to you from the things we talked about before, you must have a privacy policy, like a written actual privacy policy that also states what you do with your HR data. So if you don't have one and this applies to you, you do need to go get one. The other thing that it says is that your privacy policy has to be updated at least once every 12 months. So they say, yeah, you have to review it and make sure it's current. And then it's sort of, and I've included a few bullet points here of what it must include. There are, more information that you're going to want to put in that privacy policy. So definitely consult with a privacy lawyer in putting this together. But the things that it must include is a statement of the HR data subject's rights, right? The rights that we just went over, the right to know, the right to collect, the right to delete, and how they can exercise that right. It actually requires that you have two methods for individuals to submit requests to exercise their rights, and it requires a toll-free number. The other way that I highly recommend doing it is that it either through some sort of web page or an email address or both. But you have to have two ways, and you have to have a toll-free number that they can call to exercise that right. Okay. You have to list the categories of personal information collected in the last 12 months. Oftentimes it's recommended that you sort of break out what is sensitive personal information, like social security numbers and dates of birth and things like that, versus what other personal information you collect. So just list the categories of those and the categories of sources where that personal information is collected, the business purposes for collecting that personal information, and then the categories of third parties whom you disclose personal information to. So you don't have to state the third parties specifically. You just have to list the categories. So for instance, you might say, use service providers for, tracking and collection and, other things around applicants and employees. And that for Tenstreet, right? That would cover Tenstreet's service provider for you, and you would not have to list Tenstreet or any other specific names in the privacy policy. Okay, you also will want to have a prominent statement that data won't be sold. Of course, if you do sell data, that's a much bigger issue and thing that you're going to want to deal with that sort of goes beyond what I'm going to talk about here today. And so you will definitely want to talk to a privacy lawyer if you are selling data. Because you do have to disclose on your privacy policy if you sell data within the last 12 months. But if you don't, which most of you I'm sure don't, you need to include a prominent statement that it won't be sold. And of course, like I said before, if you have a privacy policy, just send us a link and we will include it on your Intel app. The great thing is that if you have it hosted on a web page, your privacy policy hosted on a web page that you send us your link to, every time you update that privacy policy, as long as it is at that same link, you never have to send us anything else. It will just automatically update along with that link that you send us. And it's good to review it every year, make sure that it is up to date and that it's still working. But that is how easy it is to get your privacy policy and check that box for your in Tenstreet and your Tenstreet services. Okay, let's talk about data security standards. So these are still very broad, and the agency in California has still not gone into great detail about what must be done, all the ins and outs and details of what these data security standards must be. But what they have said is essentially you have to comply with industry standards, and you have to implement reasonable, appropriate technical and physical, technical, and administrative safeguards for the personal information. And they have set out that that includes regular risk assessments, cybersecurity audits, and that companies are responsible for the data security standards of their service providers and third parties. So make sure that if you are providing some service provider data, that they, and data of California HR individuals, that they have some data security in place. Now, as I've talked about many times at the user conference, on many of these webinars, and as I'm sure you have heard several other of our Tenstreet people talk about, Tenstreet places a great deal of effort, energy, and importance on data security. We are SOC 2 Type 2 compliant. We do these audits annually. We meet those very, very strict security standards. And more than just meeting those, we go above and beyond those. We do regular testing, evaluation, and assessment of our data security above and beyond what is required for SOC 2 Type 2 audits. And then we do regular employee training. Christy can tell you, we do this every month, if not multiple times a month. We are always, always training, talking, and putting a lot of emphasis and detail on our data security. So if you have and use Tenstreet, we have met the requirements of, reasonable and appropriate physical, technical, and administrative safeguards for your personal information. So that's the good news here. All right, so let's talk about what your action items are. So we've talked about a lot of things. The CPRA is very complex. I'm sure coming into this, you could have just been like, oh my goodness, what are we dealing with here? I don't even know where to start. This is, so complex. How do I go about doing this? I tried to break it down and make it very simple and very streamlined for you. So the first thing is just set up a plan for responding to data requests. Okay, so they're going to have their right to correct, right to delete, and their right to know. Set up a plan, a policy and procedure for responding to those. All right. The next thing is prepare and implement the notice at collection and a privacy policy. You can do them again in just one document. In the privacy policy, the notice at collection can exist there, or they can be two different things. It's up to you. So get with a privacy lawyer, get those things put together, and then host them on a web page and send us the link to those. We will get them added to your Intel app. The next thing is ensure you have a data processing agreement with those required CPRA terms with all of your service providers that deal with personal information of your California HR individuals. You can check Tenstreet as done on this. If you come up with a different data processing agreement and you want us to take a look at that, great, send it on over, we will take a look at it. But it is not required. We've got that done and it is in place already. And then the last thing is implement reasonable and appropriate physical, technical, and administrative safeguards for all personal information that is within your systems. So this is where you're really going to have to turn to your IT people and say, hey, what do we got? Are we consistent with industry standards? Do we meet these requirements? And if you do, great. Now turn and look at all your service providers and make sure they do too. And you can do that through these contractual requirements. You can do, security assessments as well. You can check Tenstreet as done on that. All right, so those are your action items, and I am available for any questions that you all have. Happy to hear what you all think of this and answer any questions to the extent I am able to.
Wow, Shannon, that was fantastic. Thank you, thank you, thank you. I am waiting for some questions to pop in. We had one really good question so far. And when I started talking about the new delete feature, someone said, it's very annoying for all the primaries to get that email. And we created that just really for transparency so that one person wasn't doing something that the other wasn't aware of, and kind of to mitigate that possible miscommunication that could happen between departments and between different people who have responsibility for different areas of your Tenstreet system. I could see a world though where you could choose the specific people who need to be notified, but that would definitely be a product and suggestion. So I'll send that over to our products team just in case anyone else was kind of thinking that same thing. Just wanted you all to know that. That was one question.
Thank you, Christy. Yes, that's absolutely right. And I can definitely see where it would be annoying. We just rolled this out, and it is something that I'm sure will continue to hone and make changes to. I do want to say though, because it relates to sort of your legal obligations here, we did want there to be transparency among it and among all of the primaries. And there will be, I believe, future iterations of this where you would be able to not, do this one at a time, but do this in batches and things along those lines that will make this a lot easier. But this was just rolled out, just created. We appreciate that, and we will definitely get your feedback moved on to other individuals that sort of are in charge of making those sort of enhancements and things along those lines.
Yeah. Well, someone just popped in with a really great question. They said, I have a driver who splits his time between his primary residence in Wisconsin and his parents' home in California. Does he fall under this? Now, yeah, that's a really good question. Go ahead, Shannon.
Fantastic question. Absolutely. It's sort of gray, right? What I would say is if his primary residence, where he gets, mail, where he pays taxes, things along those, where he spends majority of his time and where he would say he resides, like where is his driver's license? Where does he regularly get mail? Things along, where is his car registered? Every one of those details sort of goes into determining where you reside, would be considered, where he resides. So it's a little bit, see, it gets even greater. Driver's license in Wisconsin, car registered in California. That's a very great area. Here's what I would say. I would say that if you only have one individual in California, it is very possible that if he could exercise his rights, it's possible, and you might want to exercise caution with that. But having one individual, your risks overall for CPRA compliance are much, much lower than if you have multiple large amounts of employees and individuals in California. So keep that in mind when making these decisions. That's something that you might want to contact a privacy lawyer about and just say, hey, I would say if his primary residence is in Wisconsin, that you could consider that he is a Wisconsin resident and not have to apply the CPRA, especially just for one employee.
Yep, for sure. That's a really great question. And so one of my main takeaways though was that CPRA applicability slide, knowing if your specific business, does this even apply, right? And so that 25 million in gross or global revenue, I'm like, oh, okay. So you can kind of know whether your company, or at least have the listing of the ways or the reasons that would make you have to comply with the CPRA. So that was really, really helpful, Shannon.
Awesome. Thank you, Christy. And again, I really appreciate all of you so much for joining us today on your Friday afternoon. I hope you all have a fantastic weekend. I hope you have some good plans or fun plans or relaxing plans. If you're going to be in San Diego at the ATA Legal Conference, again, please look me up. I would love to speak with you. And yeah, thank you all so much.
All right. Thank you. Okay. Bye-bye.
Bye.